Terms of a contract. The terms of a contract are the specific promises, obligations, and rights that the parties agree will be legally binding. The concept of terms is the classification of contractual promises to determine their content, importance, and legal effect. The concept of incorporation is the process by which contractual terms become part of a legally binding agreement. Express and implied terms. Express terms are terms that are clearly stated orally or in writing at the time the contract is formed, as shown in Bannerman v. White. Whereas implied terms are terms that are not expressly stated but are inserted into the contract by the courts or statute, as shown in the Moorcock. Express terms. Express terms through common law are clear statements made during negotiations that the courts recognize as contractual binding, as shown in Bannerman v. White. Express terms by statute law are written contractual terms that must comply with statutory controls on fairness and transparency, as shown in Director General of Fair Trading v. First National Bank. Implied terms. Implied terms through common law are terms implied by the courts to give business efficacy or reflect obvious intentions, as shown in the Moorcock. Implied terms by statute law are terms automatically included by legislation to protect parties, as shown in Stevenson v. Rogers. Implied terms by course of dealings are terms implied due to consistent previous transactions between the parties, as shown in Spelling v. Bradshaw. Implied terms by the Consumer Rights Act 2015 are statutory protections ensuring goods and services are of satisfactory quality and fit for purpose, as shown in Rogers v. Parish. Types of terms. The different types of terms are conditions, warranties, and innominate terms. A condition is a vital term that goes to the root of the contract, as shown in Poussard v. Spires and Pond. A term will be identified as a condition where it is fundamental to the contract and goes to the root of the agreement, meaning a breach allows the innocent party to terminate the contract and claim damages, which is shown in Poussard v. Spires. A warranty is a minor term where a breach does not allow termination of the contract, as shown in Bettini v. Jai. An innominate term is a term that cannot be classified as either a condition or a warranty until it is breached, as shown in Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen Kaisha Limited. Different approaches. The term-based approach is the method where the court classifies the term in advance to determine the remedy for breach, as shown in Poussard v. Spires and Pond. The benefits of this approach are certainty, predictability of outcomes, and ease of application. Whereas the problems of this approach are rigidity, potential unfairness, and failure to reflect the seriousness of the breach. The breach-based approach is the method where the court looks at the consequences of the breach rather than the label of the term, as shown in Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen Kaisha Limited. The benefits of this approach are flexibility, fairness, and a focus on the actual impact of the breach. Whereas the problems of this approach are uncertainty, reduced commercial predictability, and increased judicial discretion. Breach of terms. There are different consequences for breach of each type of term. The consequences for a breach of a condition are that the innocent party may terminate the contract and claim damages, as shown in Poussard v. Spires and Pond. The consequences for a breach of a warranty are that the innocent party may only claim damages, as shown in Bettini v. Jai. The consequences for a breach of an innominate term are that termination depends on whether the breach deprives the innocent party of substantially the whole benefit of the contract, as shown in Hong Kong Fur Shipping Co. Limited v. Kawasaki Kisen Kaisha Limited. Types of clauses. There are two types of clauses that a contract can have: exclusion clauses and limitation clauses. Exclusion clauses. An exclusion clause is a term that attempts to completely remove liability for breach of contract or negligence. The common law regulations of exclusion clauses are that the clause must be incorporated into the contract and clearly cover the breach, as shown in Thornton v. Shoe Lane Parking. The statutory regulations of exclusion clauses are found in the Consumer Rights Act 2015, which prevents unfair terms and bans exclusion of liability for death or personal injury caused by negligence. Exclusion clauses in non-consumer contracts are regulated by the Unfair Contract Terms Act 1977, as shown in Photo Production Limited v. Securica Transport Limited. Limitation clauses. A limitation clause is a term that restricts the amount of liability rather than excluding it completely. The common law regulations of limitation clauses are that the clause must be incorporated and brought to the attention of the other party, as shown in Interphoto Picture Library Limited v. Stiletto Visual Programs Limited. The statutory regulations of limitation clauses are contained in the Consumer Rights Act 2015, where terms must be fair and transparent. Limitation clauses in non-consumer contracts are regulated by the Unfair Contract Terms Act 1977, as shown in George Mitchell Limited v. Finney Lockseeds Limited. Thank you for watching this video on the terms of a contract. I'll see you in the next one.